Welcome to Immigration Quicktake. This is Ellie Rutledge-Silver with the American Immigration Lawyers Association. USCIS is now requiring in-person interviews for all employment-based green card applicants. Here to tell us more is Diane Rish, AILA Associate Director of Government Relations. Diane, thanks for joining me. What do we know about the in-person interview requirements so far?
As of October 2nd, 2017, all employment-based applicants will be required to attend in-person interviews at local USCIS field offices. This represents a significant policy change. Although the government does have the discretion to call individuals in for in-person interviews during the adjustment of status process, historically the government has waived this requirement, only requiring at least roughly 5 to 10% of applicants to attend in-person interviews. This new policy comes as a result of President Trump's Executive Order 13780. USCIS claims that this new policy will help to enhance the U.S. immigration system and prevent fraud, though this ignores the fact that the vast majority of employment-based applicants have already attended interviews at U.S. consulates overseas and gone through background checks and security clearances before coming to the United States. Under this new policy, all I-140 employment-based adjustment of status applications that were filed on or after March 6, 2017 will be required to attend an in-person interview. Consistent with prior practice, roughly 5 to 10% of applications that were submitted prior to March 6, 2017 may also be called for an in-person interview. USCIS does have the discretion to waive in-person interviews of individuals under the age of 14. Nevertheless, family members should anticipate that each family member will receive an individualized interview notice regardless of age. Finally, I wanted to point out that USCIS has confirmed that under this new policy, the I-140 petition will continue to be adjudicated by the service centers. Upon approval of the I-140 petition, the I-140 and the green card application will be forwarded to the National Benefits Center, which will review the application to ensure that it is interview ready. It will then issue an interview notice to the applicant and the attorney of record before forwarding the case to the local field office for interview.
What should members expect during the interview?
Adjustment of status applicants should be prepared to answer questions relating to the underlying I-140 petition and adjustment of status application. Although USCIS has repeatedly confirmed that field officers will not re-adjudicate the I-140 petition, nevertheless, field officers have been directed to assess the validity of the supporting documents upon which the service center relied in adjudicating the I-140 petition. Thus, it's important that applicants be prepared to answer questions relating to where they work, what they do, their educational background, and work experience. In addition, USCIS may inquire whether or not the employer still intends to employ the applicant upon approval of the adjustment of status application and whether the applicant intends to assume employment with the employer. With respect to the I-485 adjustment of status application, applicants should be prepared to talk about their admissibility and adjustment eligibility. For family members, they should also be prepared for questions, specifically relating to their relationship to the principal applicant, and be prepared to discuss the nature of that relationship. AILA members have been reporting so far that these interviews have been fairly routine. One area of concern that has been causing a little bit of confusion has been the interview notices. Members have been reporting that the interview notices appear to be fairly generic and templated, but appear to be geared more towards marriage-based or family-based applicants. This issue has been raised with USCIS and has acknowledged that they are reviewing this and that they will be issuing soon interview notices more appropriate for employment-based applicants. They noted that individuals will not be penalized for not bringing to the interview documents that are not relevant to the applications. For example, an affidavit of support, if that's not relevant for your client. Members should keep in mind that this is a new process and new policy for many field officers at local field offices who may not have a background in business immigration law. As a result, attorneys and their clients may need to serve as educators during the interview process about business immigration principles, such as the ability to pay, successor and interest issues, among other things, and how that factors into the application. Finally, given that this is such a new policy, it's encouraged that AILA members attend these in-person interviews with their clients if possible.
What resources are available to AILA members to help them and their clients navigate this new policy?
I'd like to highlight 2 AILA practice pointers which are available on the website. One is entitled Preparing for Employment-Based Adjustment Interviews, and this practice pointer highlights what to expect during the interview and how to prepare your client. The second practice pointer relates to the CIS Ombudsman Stakeholder Call, which took place on September 28th, and highlights some of the information that was provided during the call relating to USCIS's processes and procedures that they are putting in place to respond to this new policy. Secondly, I'd like to encourage AILA members to check out the Message Center, where members can report or share their experiences of what they're seeing at in-person interviews at local field offices across the nation. One active thread I'd like to point out is entitled Interviews for All Employment-Based AOS Applications. Next, I'd like to also highlight that AILA had a webinar on November 13th on this topic entitled Employment-Based Adjustment Interviews, Preparing Your Practice, which provides a wealth of information about how to prepare for the interview, what documents to bring, among many other things. And you can find this webinar on the AILA Agora website. Finally, I'd like to remind members to take advantage of the AILA network to help identify immigration attorneys who can attend the in-person interview with your client if you're not able to do so. Given that this is such a new policy and that there's a lot of emerging issues forthcoming, we encourage AILA members to reach out to the Government Relations Department with any questions or concerns. We're here to help navigate this policy with you in the months ahead.
Thanks, Diane, for joining us. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.